Hello everyone, welcome to This Family Does Everything. My name is Alex, and tonight we're going to be looking at the testimony of T.Greene. Now that I've started kind of chronicling all of the witnesses' testimony in this case, I thought this one was actually interesting because of the back and forth between the state and the quote-unquote defense in the very beginning. So let's sit back, watch, and analyze the Darrell Brooks trial.
Crime of deception. I believe that it's not relevant for purposes of impeachment. I'd ask the court to exclude that conviction from this witness's testimony.
Mr. Brooks, do you have a legal argument on that?
Yes, I do. The main thing is this issue wasn't really discussed to this length until it was time for this witness to be called to the stand.
Well, that's when I said I would take it up, is prior to that witness's testimony. I even gave you the statute that is at issue, and it's 906.09, impeachment by evidence of conviction of crime or adjudication of delinquency.
Here's
pull
why.
the statute book out, and it's in there. If you want to review it quickly, I'll give you an opportunity, but I do need to address this, and now is the proper time.
906.09.
There's a general rule in sub 1 and the exclusions under sub 2, and the factors for the court to consider in evaluating whether to admit evidence of a prior conviction for the purpose of attacking a witness's truthful character.
I see it.
Before I have you address it, let me ask the state this. How long do you anticipate your direct examination to be?
10 minutes.
All right. So someone we could and should be able to get through fairly quickly,
Yes.
both for direct and cross. All right. Go ahead, Mr. Brooks. What's your argument?
I'm still. I wanted to make sure I heard what you said, so I stopped reading briefly. I guess I would, from what I've read so far, I would go to 906.09 sub 2. It would be kind of problematic, and I say that because if I was going to take the stand, my record would be brought up, and some things on my record was done 20-something years ago, but it would still have bearing. So I believe that it should be fair. It should be the same. I believe that if the witness knew that there was a possibility that they would give testimony and agreed to give testimony, then they also agreed that their credibility can be questioned. I think that's really a fundamental thing to be able to cross-examine on my part would be to see if they're credible, to see that they would honor their oath that they give in the court to be truthful. And part of being able to ask them questions like this pertaining to a criminal conviction would be relevant.
You do understand the inquiry is limited to the following. Have you been convicted of a crime? The answer I allow is yes. They would say yes. The follow-up would be, If so, how many times? And in this case, my understanding is there's just one. Don't get into the specifics of it. That's not proper questioning for impeachment. Do you understand that?
I follow.
All right, let me hear from the state in response.
So again, looking at the factors under 90609 sub 2, just about every factor weighs in favor of not informing the jury of this conviction. We've got a conviction date of April 4th of 2006. So we've got, again, well over a decade before the conviction. We've got whether this witness was rehabilitated or pardoned. According to the CCAP records, there was a probation sentence and probation was discharged, so there's no indication that this witness was ever revoked from probation, and there's no re-offending evidence or any new cases or any new convictions. So that, again, that factor weighs in favor of not including this. Gravity of the crime, this is an entry into a locked building or construction site, contrary to 943.15 sub 1, so it's a misdemeanor offense, so that weighs in favor of not including it. It does not, on its face, involve any dishonesty or false statements by the witness. Frequency of the conviction, again, it's just the one. And in terms of any other relevant factors, as an offer of proof, I'll inform the court that this witness is going to testify about his and his family's presence near the Martha Merrill's bookstore on the day of the parade, the positioning of his children, and what he remembers in terms of the SUV driving along the parade route and clipping his two children who were seated on the curb watching the parade. There's two videos of the driving conduct in question. They are not they're not as clear as some of the videos we showed with the band. In fact, one of them is the video we showed with the band, and you can see spectators sitting on the side of the road. But in terms of impeaching the witness, I think Mr. Brooks should be fine just relying on the videos in asking the witness about that.
I object still. Entering into anything with is deceptive in nature. Just right off the bat, that's deceptive in nature. Why would you enter into something that you're obviously not supposed to be into? You entered into something because you were not supposed to be in there. That's deceptive in nature. It's also not enough information that would suggest that the probation wasn't discharged by revocation. It's not clear. And also, the prosecution just stated on record that they will only need about 10 minutes of testimony from this witness, but now they're talking about videos. That seems like it's going to be a little bit more than 10 minutes. I feel that I should be able to at least question the credibility of this witness at the very minimum.
Well, you would be able to question the credibility just through cross-examination, but let me get to the heart of this issue. And the general rule is as follows. For the purpose of attacking character for truthfulness, a witness may be asked whether the witness has ever been convicted of a crime or adjudicated delinquent, and the number of such convictions or adjudications. If the witness's answers are consistent with the previous determination of the court under sub 3, then no further inquiry may be made unless it is for the purpose of rehabilitating the witness's character for truthfulness. The sub 2 then of this statute talks about exclusion. It says evidence of a conviction of a crime or an adjudication of delinquency may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Factors for a court to consider in evaluating whether to admit evidence of prior convictions for the purpose of attacking a witness's truthful character include the lapse of time since the conviction, the rehabilitation or pardon of the person convicted, the gravity of the crime, the involvement of dishonesty or false statement in the crime, the frequency of the convictions, and any other relevant factors. So as I consider all of that, I would include in the any other relevant factors that this is a witness that has been brought to testify by the state against the accused. This conviction is for a misdemeanor offense of criminal. Can I have the exact? I wrote down criminal trespass, but I just want to make sure I have it accurate.
Yes, the statute in question is 943.15 sub 1. And it's listed on CCAP as an entry into / onto building / construction site / room.
All right, so a version of criminal trespass. All right. Apparently, the particular witness, this was 17 plus years ago. The witness was 21 years of age, was sentenced to probation. Nothing on the record before this court suggests that probation was revoked. I'm not aware of any reoffending, meaning that's the only conviction for this witness. This is a witness in this case who will apparently testify about where he was seated with his family in relation to the driving of the red SUV through the parade in front of Martha Merrill Bookstore. So clearly relevant to the case and the charges at hand. When looking at whether evidence of a conviction of a crime may be excluded, and specifically in this case, if its probative value is substantially outweighed by the danger of unfair prejudice. I think sometimes we skip over that part of the statute, which is the standard this court must look at, not just the factors, but whether in light of those factors, is the probative value substantially outweighed by the danger of unfair prejudice. As I commented on earlier, the nature of the inquiry is very limited. It's, have you been convicted of a crime? Yes or no? And then how many times? And in that case, it would be, in this case, it would be 1. In light of that, and the other factor that I noted, even though there's some factors that I could say would warrant exclusion, I think it's best to err on the side of caution, as we sometimes say, and allow the witness to be questioned about this prior conviction under the statute, and that is the very limited inquiry of have you been convicted of a crime? The answer should be yes, and then how many times? 1, and that's it. Mr. Brooks, you may ask a single follow-up on that is it true you've been convicted of 1 crime? But we're not going to spend a lot of time on that. That's going to be my caveat to all of this. You cannot ask repeated questions of this witness about that. The jury will further get instructed later on about the purpose of a prior conviction, that it bears solely on credibility, and then ultimately it's up to the jury to determine whether or what to believe. So that's my ruling on this. Now with that, it's now 4:15. Would you like the witness to testify today?
Yes.
All right. Any questions, Mr. Brooks?
No, I was just going to say, what if I didn't really want to go into it? What if I just wanted one question just to say, have you ever been convicted of a crime, and just left it at that?
That's fine. I'm sure the state's going to ask the questions first, though. That's typically how this goes. All right. Bring the jury out.
I just need a moment to
Understood.
this.
Understood.
Do you know whether your 2 kids were struck by the vehicle?
Yes, they were.
Okay. And that's consistent with where they were sitting along the curb?
Yes.
All right. I don't have any other questions. Thank you.
Go ahead, Mr. Brooks.
You stated that all the videos you just saw were accurate depictions of what you observed that day, correct?
Yes.
Have you seen any of these videos before today?
No.
So today's your first time seeing any of this footage?
Yes.
Mr. Greene, have you ever been convicted of a crime?
Yes.
Do you remember what you did when the vehicle passed you?
Yes.
You state for the record what you did immediately following the vehicle passing you?
I ran to see if my kids were okay.
You stated that your wife was standing to your left. Do you recall what she did?
No, I don't.
Do you recall checking to see if your wife was okay?
No, I don't.
Do you recall getting a look at the driver of the vehicle?
Yes, I do.
And what did you see?
I seen somebody in a hoodie with dark skin.
Did you observe anyone else in the vehicle?
No, I did not.
Could you see the entire vehicle? Passenger seat and back seats?
I don't recall seeing anybody in the back seats. The windows were tinted.
So it would be fair to say if there was somebody seated in the back, you wouldn't have seen them.
I couldn't say.
Did you get a license plate number of the vehicle?
No, I did not.
From your opinion, about how fast would you say the vehicle was traveling?
Hard to say.
After the vehicle passed you, did you observe it strike anyone else?
No, I did not.
Were you injured during the incident in any way?
No, I was not.
Was your wife injured in any way during the incident?
No, she was not.
Do you recall about how long you were at the parade before the incident happened?
I do not.
Do you recall about how long you stayed after the incident?
No longer than 3 minutes?
So you got right out of there immediately after.
Yes.
Do you recall making a report of what happened at the incident?
No.
You don't recall talking to Officer Sepakan?
I did not talk to anybody at the incident.
You don't recall making any police report to what happened?
Not at the incident, no.
In the days following the incident, did you make any report?
Yes, I did.
Do you recall who the officer was that you reported the incident to?
No, I do not.
So earlier you said that you heard a crash to your right, which alerted you to the vehicle approaching. Is that fair to say?
Yes.
Do you know what that crash was?
The vehicle hitting the band.
So before you heard that crash, you wasn't alerted to the presence of a vehicle approaching?
No, I was not.
Would it be fair to say that it was really loud during the parade at that time?
Yes.
Do you recall in the report that you made that you initially thought the vehicle was part of the parade and it was an accident?
Yes.
So it's fair to say from when you first saw the vehicle approaching that that's what you thought?
Yes.
Do you recall the vehicle swerving?
Yes, I do.
Do you remember what direction the vehicle swerved in?
To the left, towards me and my family.
And did it swerve away from your family at that point?
After it hit my family, yes.
Do you remember stating that you were not sure if the people being run over were part of the parade or guests watching the parade?
I do not recall making that statement, no.
Do you recall the make or model of the SUV?
No, I do not.
Do you recall the license plate number of the SUV?
No, I do not.
Do you remember stating that when you saw the SUV coming, you froze?
Yes.
And do you remember saying that you stared directly at it as it was driving towards you?
Yes.
And you didn't get an accurate description of the driver?
I had already stated that I seen a tan-skinned person with a hood on.
You said dark skin.
Objection. That's not a question and argumentative.
Oh, is there a
Brown.
question, Mr. Brooks? You can't testify, but you can question him. So your last statement I'll strike. Ask your question.
Did you not state earlier that you saw a dark skinned driver?
Yes.
And did you now just state that you saw a tan skinned driver?
They both seem the same to me.
Would that be yes?
Yes.
Thank you.
So from your perspective, dark skin and tan skin is the same?
Objection. Ask the answer.
Grounds.
Argumentative. Next question. You can rephrase.
What would you consider to be dark skin?
Objection. Relevant.
Grounds.
Overruled. You may answer.
It's hard to say.
What would you consider to be tan skin?
Darker than Caucasian, I guess.
Would it be fair to say that there is different types of shades of color to people? Would that be fair to say?
I'll
Yes.
stipulate to that.
He answered the question. His answer may stand.
Do you recall if the driver was doing anything, gesturing or doing anything?
No.
Do you recall hearing gunshots?
No.
Any idea why that would be in the report?
Objection. Lacks
Grounds.
foundation.
Sustained as to the form of the question. That's foundation.
Do you recall stating that, well, let me read from the report. Thomas stated they heard gunshots and he picked up Charles and they ran back to their vehicle. Do you recall making that statement?
I recall an officer coming down the street yelling gunshots fired.
Any idea why you would be mistaken in your report that you heard the gunshots?
Objection, mischaracterizes.
Grounds.
Sustained a lack of foundation as to the form of the question.
I'm reading directly from the report now. Directly from the report.
That's not the issue, Mr. Brooks. The issue is it his statement or a summary of his statement? Because that makes a difference to the foundation you have to lay.
It does not say summary.
I'll object if that was a question for the witness. If it was an argument with the court, I'll withdraw that objection.
I believe it was a statement to the court. I don't know what you're looking at, but if it's a witness statement, typically there's something either signed, sometimes police officers summarize what witnesses say to them, so that's what I'm referring to as a summary. And if it's in a summary, typically if it's a direct attribution to a witness, it's in quotes. So with that, ask your question.
This is not in quotes, but I'm going to assume this is summary. Do you remember stating in your summary report that you heard gunshots?
No.
Do you recall if the injuries suffered by your family were broken bones?
They were not.
So were they bruises?
Yes.
About how long would you say that your family was treated at the hospital before being released?
Hard to say.
Was this a significant amount of time, a few hours?
A few hours, yes.
But to your recollection, they were treated and then released?
Yes.
And who is Nicole?
My wife.
Do you recall Nicole making any statements to law enforcement?
She made one, yes.
Do you recall Nicole stating that she heard gunshots?
No, I do not.
Grounds.
And an objection, it calls for hearsay, it's sustained. Any answer that he gave is struck. Jury shall disregard it.
Your Honor, I'm also reading this from the summary.
Question him about what he knows, not what other people said to him.
No, the question was, did he know? Do you recall her saying that she heard gunshots?
You're asking him to confirm hearsay, so it's sustained. Next question or rephrase. Like, are you aware?
Are you aware if she heard gunshots or not?
I'm not aware.
Is it fair to say that right after that you ran straight to your vehicle?
Right after what?
Right after the incident.
There was a slight delay,
And what was that delay?
seeing if our kids were okay.
And then from that, straight to the vehicle.
After the officer came running down the street saying shots fired, we picked up our kids and ran.
So you decided to leave after you heard an officer saying shots fired, or because of the incident at the parade?
after the officer said shots fired.
So would it be fair to say that you weren't initially inclined to leave because of the incident, but because of the shots fired?
Objection.
Grounds.
Overruled. He may answer. And then move on.
Could you repeat the question, please?
Would it be fair to say that you were prompted to leave because of the shots fired and not the incident that happened at the parade?
I don't really understand what you're asking.
What prompted you to leave?
When the officer said shots fired.
So the incident that happened didn't prompt you to leave?
No.
Grounds.
Overruled. He may answer if he understands the question.
We did not want to leave right away because my son said he couldn't feel his legs, and there was a woman there helping us that said he might have a back injury, that we should not move him.
To your recollection, was that woman a nurse or a medical professional?
I don't know.
Would it be fair to say that she was making an assumption?
I don't know.
Do you recall the woman's name?
No, I don't.
Do you recall if she was a spectator or someone marching or?
I don't know.
Do you recall the description of the woman that told you not to move your child?
I'll object. Relevance.
Grounds.
Overruled. He may answer.
Caucasian, blonde hair.
So it'd be fair to say she seemed pretty concerned.
Very concerned.
So why would you not immediately leave at that point?
Because I didn't know if he had a back injury or what the extent of his injuries were. And if it was a spinal injury, I didn't want to pick him up.
Did you try to make a call for medical attention at that point?
I did not.
And what prompted you not to seek medical attention if you had a assumption that the injuries could be severe?
This all happened within about a 2-second time frame. I mean, it was so fast. Everything was chaotic, and I mean, there wasn't really time to do anything besides try to see if my kids were okay and try to compose myself to take care of them.
So it would be fair to say that you were pretty much like just frozen. You didn't know what to do and how to go about doing it.
Yes.
Do you recall your wife trying to call for medical attention?
No.
Do you recall anyone that you were standing next to or in front of attempting to call medical attention?
No.
Do you recall saying in the summarized report this statement? Thomas stated Charles was laying on his back and had blacked out.
To my recollection, yes.
You recall saying that to the officer?
I recall my son saying that.
Do you recall making that statement to the officer that interviewed you?
No, I do not.
Would it be fair to say that is in the report because you may have said that to the officer,
Yes,
but you don't recall.
I do not.
Did you see any other children struck by the vehicle?
The band.
Any other
Right.
children?
Small children?
Small children.
No, I do not.
But you do recall small children being present, correct?
Yes.
No further questions.
Can you redirect?
Thank you. You testified on cross-examination that you initially thought the vehicle was part of the parade and that it was an accident. Do you recall giving that testimony?
Yes.
Did you continue to think that it was an accident?
Objection. You're saying.
No, I did.
Hold on. Overruled, he may answer.
Once the vehicle kept going after hitting the band, I realized that it was not a part of the parade.
What about the vehicle's path of travel led you to that realization?
The speed that it had accelerated.
You recall testifying on cross-examination that you don't recall the make and model or license plate number of the SUV? Remember saying
Yes.
that? How many SUVs or vehicles in general did you see striking people during the parade route?
Objection. Irrelevant.
Overruled.
Just the one.
You testified that you'd been convicted of a crime in the past. How many times?
Once.
You testified a little bit about the injuries that your two kids sustained. You had a third child with you at the parade, is that right?
Yes.
And was that third child injured in any way?
She was not.
Okay. Speaking about the two kids who were, do you recall in general what their injuries were?
My son had nerve damage to his knees, and my daughter just had severe bruising.
Do you know what part of their bodies, respectively, were struck?
My son was struck in the knees, and my daughter was struck in her hand.
Do you remember if it was the right knee or both knees, or the left knee?
It was both knees.
Oh, hold on. Objection is overruled. He may answer. Can you repeat your answer?
Both knees,
And what about your daughter? Which hand?
right hand.
And they were sitting facing the parade route?
Yes.
So what direction would the SUV have traveled from their perspective? Right to left or left to right or something different?
Right to left.
Okay. I think we're all set. Thank you, Your Honor.
All right, thank you, sir. You may step down.
Thank you.
And Your Honor, may we please excuse this witness?
You may. This will be our last witness today. I will have the instruction for the jury before I excuse you. Do not begin your deliberation. Anything else we need to address today from the state?
Matter, the defendant did raise an issue where he cited 3 cases regarding jurisdiction of this court to hear this matter. I have had the opportunity to review those 3 cases. I am able to address those now if the court wishes.
I'd like to address them tomorrow morning. I frankly need to read them, so. All right, anything else from the state?
No, thank you, Judge.
Mr. Brooks?
Just so I'm clear, on these subpoenas where it says you are further required to bring with you the following, do I leave that blank or what should I put there? Just so I'm clear.
I can't give you advice on that. I only wanted you to understand that witnesses would not generally have their police reports or statements made. Those are usually kept by the police department. And so you would need to subpoena the custodian of the police records in order to get copies of that. If you think there's something else that they have, that would be in their possession and that's relevant to this case, that would be different. So I hope that adequately answers your question.
I don't understand, but
If there's something specific, you can ask the state if there's some follow-up based upon the discovery that you have. But you should have everyone's
I
statements.
guess the only thing I was so should I bring your statement? I mean,
I don't know that they would have it. What I'm telling you is you should have every statement in that box, or you should subpoena the custodian of the police records, or ask the state if you think you're missing something.
I'm clearly missing something. I don't know what to put right there.
That's the best I can do for you, sir. I can only review them for completeness. The state referenced an objection based upon their review of them. So whether you put that information in or not, that's up to you.
Would it be sufficient to just put
You can leave it blank also, correct, Your Honor?
Yeah, you don't have to fill it in. It can be left blank. If I'm not answering that correct, I don't want you to think you have to put something there.
Yeah, that was my impression. You know, usually when you're
Got it.
It's the same thing with a job application. You're not supposed to leave nothing blank.
Okay, let me answer it this way because I was not tracking with that one. You only fill that out if there's something specific as it relates to this case that you want them to bring. You're not required to, though.
Okay.
There's a subpoena, and there's what's called a subpoena ducis tecum, which means bring something with. If you just want them to come to court and testify, it's just a plain old subpoena. So hopefully that helps.
That is clarification.
All right. I'll address the other issue tomorrow morning. I'll give you some time while you're sitting here to get the subpoenas all filled out so that the state can look at that and start working on getting them served, with the exception of the one that they indicated was out of state, okay? Anything else from you then tonight, Mr. Brooks?
That would be it.
All right. Thank you, everyone. We are in recess.